Good morning. Can everybody hear me okay? Little low. It's coming up. Hello. Welcome to 9:45 Central Time. Everybody's so excited. Everybody get enough coffee? Everybody ready for this? This is going to be our health session today. We're talking about basically the relationship between federal and state regulators and communication. We have several experts here. We have some experts that will be joining us virtually as well. And so just to kind of kick it off a little bit, I still remember a conversation that I had with a former CEO of the NAIC who was very expert in insurance, wrote books, had a university named after the family. I mean, just loved insurance. I remember she coming up to me and say, health insurance is not insurance. It doesn't follow any economic rules. It's not right. It shouldn't be called insurance. And I said, yeah, it is. It's just different. Very different. It's a different kind, but it does follow economic rules and things like that. So from that on, she said, I will not do anything on health insurance. You take care of that. And I said, yay. Because everybody here who knows health insurance knows it is very different. And especially when it comes to what we're going to be talking about today, and that's the relationship between the federal and state regulators. For every other kind of insurance, we have taken very seriously McCarran-Ferguson. States regulate insurance. On health side, to know, there's a lot of federal regulation kind of combined with state regulation, and it gets a little fuzzy sometimes, and communication and cooperation are definitely necessary, especially since the 1980s, and we had HIPAA, and we started with this concept where federal law would set a minimum standard for private insurance, and state laws that prevent the application of the federal law would be preempted, but otherwise states can regulate. States, in fact, are the primary regulators, but there's still this overlay of federal oversight, federal regulation, and things like that. So what we're going to be doing today is looking at 3 examples from current issues where you have the federal and state regulators working together and looking into how they communicate, how they set things up. And we're going to start with, I hope, 2 virtual presenters. And that's going to be Erica Weimeyer from the Illinois Department of Insurance and Beth Baum from the Department of Labor. And here they come, right on cue. And they're going to be talking about mental health parity. How many here work in the area of mental health parity? How many have completely figured out how it works? All right, there we go. All of them down. This is a very complicated thing where you have federal regulation and then the states are trying to enforce this as they work with their carriers. So thank Erica, thank you, Beth, for being here today. Can we do a little mic check to make sure we can hear you? Because it'd be really pointless for you to be here if we couldn't. Not yet. We're getting there. They're still on mute. I'm looking at the technical people because I have no idea what to do.
Yeah, I think it's
Hey, there we go. Hey, very good. We got one. Beth, can you? Well, good thing we're starting with Erica. Oh.
Here, I thought we were starting with Beth.
I know my notes say we're
There
going
we
to start
go.
with Beth. There we go. Okay.
Oh, yay.
So we're going to start with Beth. Beth was at the Department of Labor, and as you know, Department of Labor came out with all the rules and regulations, especially the NQTLs and how you do that. So I want to start with a question is, how did DOL kind of begin developing the regulations and the enforcement procedures for mental health parity, and how did they reach out to state regulators to receive input and to coordinate? So Beth, can you start us there?
Sure. Good morning, everyone. Thank you for having me. So I think to start, I'll note that staff from my office has been attending the NAIC meetings for many, many years. And the coordination with state regulators was kind of a natural fit because we are always coordinating as part of the tri-department process. My office works on regulations and guidance under Part 7 of ERISA, and we work with our colleagues at the IRS and Treasury, as well as HHS, to coordinate on our shared interpretive jurisdiction and our split enforcement jurisdiction to ensure that there's consistent enforcement of the requirements across the department, the federal department. So, you know, going back to the mid 90s with HIPAA, we've had a lot of coordination with the states, and the reason that that's important to us is because starting with HIPAA portability and non-discrimination and going all the way up through the current day, we've had our requirements are what we call a federal floor. So states can and many do enact more protective requirements, and we are always happy to help ensure that state regulators have the support they need to go ahead and enforce those requirements. So I think with respect to MAPIA, before we had the MAPIA working group meetings at each NAIC meeting, started with a little cluster of folks huddled in a corner between sessions to start coordinating on MAPIA, you know, going all the way back to the early 2010s, and in the 16 years since MAPIA was enacted, almost 16 years in a couple weeks, we've done a lot of coordination. And so now when the MAPIA working group meets at every NAIC and sometimes virtually in between meetings, it's a great forum to coordinate on interpretive and enforcement questions. We're also always in touch with Erica and Jane Beyer and the staff of the NAIC to keep them up to date. Most recently, as we've been working through the process of developing and issuing our MAPIA proposed rules last summer, and then the final rules we just released last week.
B working group, how many have been to one of their meetings or on one of their calls? That's where the states work together. Erica, question to you. How are state regulators currently working with DOL and CMS to coordinate enforcement efforts, get questions answered, and things like that? How are they doing that?
Okay, good morning. As Brian said, my name is Erica Wadenmeyer. I work for the Illinois Department of Insurance as the Chief Market Conduct Examiner, and hit on a lot of high notes of how the states are able to work with our federal partners in this topic. Yes, regular communication with the working group along with coordinated efforts. For example, NQTL comparative analysis is an amazing example of this. You know, after the Consolidated Appropriations Act was passed, and it gives the federal partners and the states the ability to ask for that information, it created really a really great place for communication and collaboration on that topic so that states and our federal partners were able to enforce that consistently. So we know that that communication is happening. Our federal partners also have a wonderful display of resources across the nation that give states the ability to outreach to every single one of them so we can coordinate on a state level basis as well. And it's really worked out well within the working group where we've been able to build out examples and how those things might work, create those lines of communication, and it's been really an amazing partnership.
Part of those mental health parity working group calls and meetings, and then also with DOL. Question, if a state does have some questions, they're going through a review of a company, and they have questions for DOL, who should they contact? Beth?
Sorry, guys, I think I was double muted. I was saying folks can get in touch with me, and I can, if it's not an interpretive question that my office would handle, we'd be happy to get it over to our enforcement folks if that's more the lane of the question.
So I appreciate that. Now, Erica, kind of how you see going forward. Obviously, we have a new final rule out from the three agencies. There'll be a lot of work trying to implement that, but how do you kind of coordination going forward? How do you see, are there ways to improve the communication? Are there things that states, regulators can do to make this process work even better?
I think there's a lot we still need to learn about the rule before I can truly comment on that part. But I'm looking forward to the working group having the opportunity to meet with our federal partners, have some walkthrough, allow our subject matter experts to ask some questions about how they see some of the pieces working, implementation, things of those nature. And I think as long as we keep those lines of communication open, we do, the more and more we improve that communication, we talk to each other and get feedback from both ends, it's going to benefit from everyone, for everyone, excuse me.
Better? What can be done better to improve this coordination?
You know, I think, like Erica said, we're going to do more going forward just because the final rules are now out. You know, this is definitely not the last you've heard on mental health parity. It's a big priority of the Department of Labor and the administration as a whole. And we plan to issue more implementation guidance and answer questions related to the final rule. So we'll continue to keep in touch and I think just keep an open mind so that if a state or a group of states has an idea for something that would be helpful to them, I think we're willing to do whatever we can to help folks comply with the rule in the private sector and also to help the states implement and enforce as well.
Webinar on Thursday, I believe. You want to make a little pitch for that?
Yes, so Thursday at 2 o'clock Eastern, we're going to do a national webinar to walk folks through what is in the final rules. It'll be about 75 minutes, and you can register through the Employee Benefits Security Administration's website. And I understand it will be recorded as well if you're not able to make that time, but probably better for folks to register to make sure that they have access to that recording once it's available.
If you're receiving any of my health updates, that it's been in there, the link's in there as well. And we're also working with the three departments to get a regulator-only meeting to walk through the final rule as well and get some more specific questions. But I think the key here, I think both would agree, is talk. So as you go through these reviews, as you have questions, you're not sure how to interpret the federal rule, or you know how, but you need some backup when you're talking to your carriers, you can talk to DOL. They are there to help. CMS is there to help, and they can help you out. So any last words from either of you on this topic?
No, just thanks for the collaboration. I think we feel like, the states have done a really great job implementing and have kind of taken the lead on some aspects of NPI implementation and enforcement. So we're really happy to be a part of the collaboration and help to move the needle forward so that folks can continue to get access to the mental health and substance use disorder benefits they need.
And I would agree with Beth's comment, and I encourage and hope for additional participation from any state who is getting started in the middle or advanced in this topic in their states and enforcement to come to the meetings, contribute, ask questions, collaborate. We're all learning. It's a complicated topic and very important one as well.
Can you all hang on to watch, and maybe there's some questions at the end? Appreciate it. Thank you. All right, we'll move on to the second topic, which is a little different. This is marketing. And in marketing, we have things like Medicare Advantage, where basically the federal government has preempted state regulation of the plans when it comes to marketing, but the states are still the regulators of the agents and brokers. We have the ACA, where basically under the federal rules, states regulate the plans, as well as agents and brokers, but there is, how many have a federal exchange? Okay, a federal exchange, there's that role of the federal government who approves agents and brokers to sell through, so there's a coordination there. And we have today Martin Swanson from the Nebraska Department of Insurance, who also chairs the Improper Marketing of Health Insurance Working Group over at the D Committee. Gina Zanovich, who's with CMS, Kayla Mendenhall, and Jonathan Slade. They're from CMS. They're here to kind of talk about how there can be coordination and maybe some things that can still work even better. I'm going to start with Martin. This is his favorite topic. He lives this and breathes this. So what have been some of the key improper MA and ACA marketing practices states have seen recently? What should we be looking for out there?
Oh, what haven't, is this on? Okay, great. What haven't we seen is really the question, Brian. We have seen everything from those phone calls you get from either somewhere here in the United States or offshore. We've seen everything on the internet, so there's unsolicited emails that come. If you're shopping for a particular plan, sometimes you go to the wrong website. And if you go instead of healthcare.gov, you go to healthcare.com, you're going to get spam. We've seen emails come in where they've utilized former President Trump, Trump Care for Healthcare. They use current President Biden. I don't care which administration it is. They're going to find a way to use and make it look like that the federal government has done something and has moved and is trying to put you in this particular plan. Well, that's going to connect you to more than likely short-term duration, maybe a discount medical plan or indemnity plan, something like that. We just are warning people to be cautious on that type of marketing activities. The other one that we see is utilization of governors from different states to make it look like states have passed something. As a person has to review every piece of legislation that goes through Nebraska's legislature on health. That didn't happen. And they use company logos and cards that make it look like it's official. They got contracts with those particular companies. They don't. So anytime that anybody sees that, if you are working for a company or you're working internally, make sure you get that information, start that investigation, and then let CMS know too as well. We have agreements with them that we give them information and they give us information back, and we can coordinate. If we knew that producer or somebody sending that unsolicited information out or making those calls, maybe we get them off the marketplace that way. So that's what we've been seeing, Brian.
Gina, how has CMS worked with states, and what are some of the things you're doing to try to address? I think everybody's heard of these improper switchings and other things, and both in MA and ACA. So what are some of the things CMS is doing right now?
Sure, thank you. And I just want to start by saying, we've seen tremendous growth in the marketplace, and at least in the federally facilitated marketplace, that's largely due to agents and brokers supporting enrollment. So we want to work with our agents and ensure consumers are having a really great experience. On the flip side, we are aware that there are agents conducting unauthorized activity, like switching consumers' plans and enrolling them without their knowledge. And so, while on the marketplace side, we can end an agreement with an agent, we really want to get the information to states who can terminate the license. And so we work to get that information to states. Until termination. We've also, hopefully, made the request process for states easier. If a state has received complaints or wants to conduct their own investigation, they can reach out and request enrollment or other data that we have. We have also put together some reports to reflect complaints coming in associated with agents so that states can more easily identify or use it as supporting information. I certainly don't think we're done. We want to make sure that what states need, they are receiving in a timely manner. But I think at this point we have absolutely closed some of the gaps that have existed.
There's been a lot of work, actually, just since our spring meeting, where we talked a lot about these issues. There's been a lot of work done, but there's still much to be done. And How many know that open enrollment's coming up soon? November 1st, so we'll see what kinds of games will be played this time and watch that. So, Jonathan, how can states improve their communication? So they have problems, they have issues. How best to contact CMS and to talk to one another? We've got Kayla here as well. So how can they communicate all these issues?
Thank you, Brian. As you can imagine, depending upon the issue, there's basically multiple paths in which you could come to CMS, and I want to help clarify basically where you can go. So for the Medicare Advantage and Prescription Drug Plan, Part D, we have Department of Insurance liaisons, which I'm sure either you or your colleagues are probably interacting with. And these folks are, real people like Kayla and Gina and myself here that definitely look forward to, talking with you about general policy questions, maybe upcoming regulation changes, et cetera. They can basically be your facilitator if you need to ask something or just get clarification. And I know several of them, and they really enjoy interacting with you and appreciate the conversation. So I'm trusting you all, and these will be shared after the meeting here, with a lot of personal email addresses associated with each state. So these are not to be shared externally. These are for our partners in state regulation, but these are the people that you can ask those general questions of. And similar to that, on the marketplace side, we have a state engagement coordinator. They still act as kind of a liaison for those general policy questions, maybe upcoming changes to regulations, et cetera. And those also vary by state, and we have those listed here as well. So if you have a general question, right, these are your folks to go to. Or you're just not sure, basically, you just need to ask, hey, what do I do? Depending upon the program, marketplace or Medicare, either a DOI liaison or a state engagement coordinator. Now, when it comes to an individual's issue, a person that has a problem with a Medicare Advantage plan, a consumer has a problem with a marketplace plan, we have stood up new general mailboxes. We had a realignment earlier this year. Many of you may know there's 10 regional offices, and we each kind of had our own process. We've consolidated that down. So you may not have this consolidated email address. This is for those individual problems that a person is having, and you're trying to facilitate a resolution for. Some of those escalated cases where a person's having access to care issues or some complicated enrollment issue, we want you to correspond with these mailboxes. These are staffed by a whole team of people. Make sure there's coverage for it, and you're not going to get missed by somebody that, one of the DOI liaisons or SECs may be on vacation. So these are definitely a resource for you in terms of like trying to get a resolution for an individual problem. Now, I'm going to turn it over to Kayla here for a second. She's going to talk about one of our systems for casework and some training and some access.
Morning, everyone. So in order to access, there's been 2 reports created, one for the states and one for the issuers. This report has information regarding the bad actors making these switches in each individual state. If you look at, the slides will be sent out, but there is a RegChat link in order to show you how to gain access to this report and provide a little more technical knowledge on what is shown on the report.
How many are familiar with the HICS system? Have you been going to that? It's been greatly improved this year and accessing the reports, and so we appreciate that. But make sure you're going and accessing it and getting that information. So, Jonathan?
Yeah, so after 60 days, your account will be suspended, so that's important. If you have that issue, we have a resource mailbox for that, HICS_access. You can email them, and they'll help you get set back up. We also have the complaints tracking module for those Medicare Advantage and Part D complaints. Kind of a sister system, but it's definitely a different type of access and access differently. So we've also given you kind of basically some resources that you can reach out to if you're interested. There are also some reports in there on, misrepresentation cases, or generally what we call marketing cases as well. Far fewer, but there's still some, issues there within that program that you may be interested in. And again, if you've got questions, you can talk to your DOI liaison as well.
Thanks, appreciate that. We'll go back to Martin. What are some of the challenges states face in enforcing their agent and broker laws through all this? We're getting the information. CMS is doing a better job. I mean, we're getting it there. States are doing a better job of requesting the information. But what are some of still the challenges in you being able to actually enforce your state laws?
Right. It is getting better. The communication is much more fluid than it had been in years past, which is great. The thing that we are currently in discussions with CMS is how much information can we obtain to do a successful prosecution, whether it be an administrative case or if it does trigger our felony statutes for fraud. So one of the things that we're working on with CMS at the moment is they're under the constraint of the Privacy Act, and I'm not sure of the federal statute on that citation, so I won't even attempt that right now. And the question really is, even though we have these agreements, is how much information can they release to the states that is minimally necessary to view the information to do a successful administrative action. So right now the negotiation is what is minimally necessary. So the question I would have for the people in the audience and to take back with you and talk to your legal divisions, if you could please, figure out what you think is minimally necessary for you to successfully prosecute under your state statutes. And please bring that information back to myself and to Brian, and we can take that back to the folks at CMS. You know, for me, I'm a former prosecutor, so my answer to that first question always was everything, and then I'll sort through it. But, you know, think about that question from your perspective under your state laws. What is necessary for you to say these folks are untrustworthy or incompetent in the business of insurance? If it's a fraud statute, what do you need for chain of evidence and custody to make sure that you can prove it beyond a reasonable doubt, or at least give that to your fraud division to investigate for beyond a reasonable doubt, and to explain it to your district attorneys, your county attorneys, or your attorney general's offices if you need to. But start thinking about that question and what you need to do a successful administrative action. I know in Nebraska we've had some of those in the past. We've gotten the information from CMS, and I see one of the attorneys in the audience back there that's done those cases for us, and I'd ask him to wave his hand, but I don't want to embarrass him more than I'm already doing. So, but that's what we essentially need, Brian, so thank you.
Great. Now, Gina, one of the things CMS is doing right now is in the process of basically about 800 agents and brokers who sell through the exchange, who have a lot of complaints and suspicion of switching without consent and things like that. Some of the departments of insurance are getting complaints from some agents, brokers who got suspended saying, wait a minute, I was the original writer, I should have been kept on there, et cetera, et cetera. If they get complaints from the agents and brokers about something you're doing, who can they contact? So, what's your home phone number?
Right.
Yeah, right.
We'll throw that up on the screen. Certainly, you know, the states are welcome to reach out to me or the state exchange coordinators to let us know what it is that they're seeing or the trends of the complaints. But, you know, we have heard some of those complaints from agents ourselves, and there is a process for the agents to go through a rebuttal and reconsideration. So when they are suspended, the reason and information is shared with them, and they have the opportunity to prove that they have evidence of consent, or, you know, to share whatever it is that they have with us. If we don't think that that is enough and we move forward with termination, they still have another opportunity for a reconsideration to send in additional extra other information. So it's not like we're just you know, ending an agreement without the agents having an opportunity. So my big thing here is they should have the evidence. If they have the evidence, they can send it to us and we will review that and proceed as appropriate.
Any last thoughts from this group about kind of going forward, what can help in coordination and communication? Any last thoughts?
One thing I would just mention too is on the agent switching issues, which you'll hear more about here tomorrow. But one thing that we're thinking about too, if there is an appeal of the producer being removed from the marketplace, if we could get a copy or if the documentation of that appeal, just because it may. I know we've discussed age yet. It's one of those things too that, and we can use that for untrustworthiness or something to that effect.
That's on the record now, again. So, yes, and if you're interested in the improper marketing issues, there is a session tomorrow. What time is that one? Do you know, around noon?
Around 4 o'clock, I think.
The 4 o'clock, so 3:30 or 4?
Last ones,
Yeah, so tomorrow, so if you want to see Martin again, talking about these issues, he'll be there. All right, thank you very much. Let's move on to our third session. So we've had mental health parity, which is basically states trying to enforce a federal law, rules and regulations. Lots of questions, a lot of coordination necessary. We've had this where states are trying to enforce their laws and agents and brokers that coordinate with a federal program. Now we have what happens if there is a federal law that applies to these people and state law applies to these people, and how do you all work it all together? And that's called the No Surprises Act. How many states out there have a balanced billing or No Surprises Act of your own? Okay? And as you know, the federal government then came in and said, here's one, and sometimes it applies to the rest of self-funded plans or some other certain situations or certain providers that the state law doesn't apply to. So there's a lot of coordination necessary and communication. For that, we have Jane Beyer here today with us, and virtually we have Sam Safzin and Michelle Koltoff. Hopefully we'll bring them up for this third session from CMS. I did want to start with, hello Michelle, how are you? And Sam's coming up. We're going to actually start with Jane, though. You're a state, Washington, that has your own No Surprises Act. So how has that coordination been, trying to figure out which law applies when and where and how and all that kind of stuff? Start us off.
Thanks, Brian, and thanks for the opportunity to speak. So as Brian indicated, and I saw from raised hands, at the time that the No Surprises Act was enacted, there were about 15 states that had already enacted their own comprehensive balance billing laws. And when you read the NSA, you could probably find a piece of one of those states' legislation somewhere in the NSA. And so we appreciate the fact that Congress learned from states' experience and also in the NSA explicitly acknowledged the states that have comprehensive balance billing laws and allowed those states to retain their out-of-network sort of payment standard and also to retain their own dispute resolution mechanisms. So while we appreciate the deference that Congress gave the states, it does complicate enforcement to a certain degree. And then Washington State and about 6 other states further complicated enforcement because since we had enacted our laws before the federal law went into effect, we gave self-funded group health plans the option to opt into our state law so that those big employers would be able to give balance billing protections to their own employees. So that's sort of an additional, what can I say, wrinkle on. And we really appreciate the fact that when the NSA was adopted, CMS approached all the states and said on a state by state by state basis, let's figure out who's going to enforce what provisions of the NSA, including some other provisions of the Consolidated Appropriations Act that the No Surprises Act was sort of integrated into, and who's going to enforce which provisions against which entities. So just as an example, in Washington State, while the Department of Insurance, the Insurance Commissioner's Office, regulates issuers, our State Department of Health regulates hospitals and they regulate ambulatory surgical facilities. And like many other states, we have a separate board or commission that regulates physicians. So when CMS approached us and said, let's figure out our enforcement letter, it meant coordination not only between CMS and the DOIs, but it also meant at the state level, the DOIs having to then coordinate with our state departments of health and our state provider regulatory entities or disciplinary bodies, as we call them. And in addition, after the NSA passed, Washington State came in and we enacted our own law to update and align our state and federal law, but also retain some greater consumer protections. So for example, in Washington State, a provider can never ask a consumer to waive their balance billing rights, where under the federal NSA, there are some circumstances where that can occur. But beyond the enforcement issues, I also want to point out a great opportunity that we had by working with our partners at CMS and DOL and Treasury. I don't know if any of you saw it, but if you look out the window right across from us, there's a building that has a massive painting on its side that says, "Are you experiencing a crisis, or are you thinking about suicide?" And it's got the 988 line. So I'm assuming folks have heard about 988? Yes? Yes? Okay, hopefully you have. And the 988 system is essentially the crisis line for people to call if they're having a behavioral health crisis. And the 988 system is able to resolve probably about 70% of the calls from folks that come in. But behind that system, if somebody's experiencing a crisis that can't be addressed on the phone, we need to have mobile crisis response teams or crisis stabilization facilities that can help the folks where a phone call isn't sufficient. And in 2022, when our legislature aligned our state law with the federal law, our legislature said, you know, the emergency room often is not the best place for somebody who's experiencing a behavioral health crisis. We've heard about emergency room boarding. We may have family members or friends who've been in that position, and it ain't good. And so we said mobile crisis response teams, crisis stabilization facilities are essentially emergency rooms for people experiencing a behavioral health crisis. So we extended our Balanced Billing Protection Act and all of the emergency access provisions that are in federal and state law to these settings, these behavioral health crisis settings. And working with the Kennedy Forum, we went to our partners at CMS and we said, is there any way that we can use this concept through the No Surprises Act? And we were very, very pleased when FAQ Part 55 was issued, and it's in question 10. And basically the tri-agency said, yes, it's up to the state and how they license facilities. If states license a facility that provides behavioral health crisis response services, i.e. emergency services, and it's licensed as a facility that's separate from a hospital, it can come under the No Surprises Act. And let's remember that the No Surprises Act doesn't only apply to fully insured health plans, it applies to self-funded health plans. So the great thing about this opportunity is this is an opportunity for a state through its laws to extend balanced billing protections to behavioral health crisis services, not just for people who buy fully insured health plans, but also for people who are enrolled in their employer's self-funded health plan. And we totally appreciated the cooperation and the work that we did with the agencies on that.
So communication and cooperation are key here.
Yes.
If you do that, you can do some great things. I think we're going to turn now to Michelle and Sam, because basically the question is, what happens if the federal government finds that a state-regulated carrier has violated the federal law? How is that communicated? How is that worked back and forth with the state regulator? And Michelle, is that? I think muted still. Still muted. While they're working on that, looks like it's coming off. As soon as I start talking. There you go. All
I
right.
think you all can hear me now. Thank you for bearing with the technological challenges. And thank you for having us. I'm going to talk a bit about kind of the plan and issuer side of NSA enforcement, and Sam will kind of handle a lot of the provider. That's how we've divided the work at CMS and how our teams work together. So generally, you know, when we receive a complaint against a carrier or an issuer through the No Surprises Help Desk, the very first thing we do is determine who has authority to investigate it. In general, as you know, Brian and Jane just kind of talked about, the NSA enforcement is pretty complicated. And so under the statute, states have the express primary enforcement over health insurance issuers, providers, facilities, and providers of air ambulance services. And at CMS, we really recognize and fully support this fundamental role that states play in regulating the healthcare industry. And we do hope that states will enforce as many provisions they can, either directly or through a collaborative enforcement agreement. For those of you who don't know, a state is able to request a collaborative enforcement agreement with CMS if the state agency maybe lacks authority to enforce a specific provision, but wishes to conduct applicable compliance activities such as form filing, complaint intake, investigation, and through that would work to seek voluntary compliance over their applicable entity. And if the state's efforts to obtain that voluntary compliance under the collaborative enforcement agreement is not successful, you're then able to refer the matter to CMS for possible enforcement action. Of course, CMS also investigates and enforces provisions where a state is unable to enforce or otherwise fails to enforce a provision. And also, we are just kind of one piece of the federal enforcement puzzle. While we are responsible for enforcing the No Surprises Act for all non-federal governmental plans in all states, and in, the circumstances I just mentioned, the Department of Labor has enforcement authority over health coverage provided by private sector implant-based group health plans, and the Department of Treasury has authority over church plans. And we really do work closely with both departments on both the policy development side, but also the enforcement activities side, and we share trends we're seeing, results of our investigations, complaints, things like that. So as with other enforcement areas, the NSA enforcement is also a partnership with CMS and the states. And we know that effective enforcement really requires this coordination. During the course of an investigation at CMS, we work with our state entities as appropriate, and we share findings of our investigations or complaints with the State Department of Insurance at the conclusion of our investigation. We are also conducting market conduct exams, and so we include the State Department of Insurance on any formal communications. So when a call letter is sent out to initiate an exam, any draft reports that we are sending to the issuer, and of course our final reports. And these market conduct exams do include, for the NSA in particular, our QPA audits. We hope that this ensures that the DOIs are aware that we are investigating an issuer in their state, and of course are aware of the results of any of our market conduct exams. And just another note is that we do post all of our final reports on our website. In terms of working with states, we also continue to provide NSA-focused resources, technical assistance, and education to all of our stakeholders, since these requirements are still new, and we are still, aiming to increase compliance with the No Surprises Act. The No Surprises Help Desk is a great resource that offers a no wrong door approach for providers and consumers. And we also look forward to continuing conversations like this, and hopefully more, with our partners in the states to hear from you guys, what you guys are finding in terms of non-compliance and how we can work better to help avoid some of these issues from happening, and really to help ensure that consumers are getting the protections that are afforded to them under the law.
Great. Thanks, Michelle. Now let's go a little more difficult. Let's go to the providers. I know states always have a difficult time dealing with providers. They don't really have that connection. So how does it work on the provider side?
Sure. Thanks for having us. Hopefully you can hear me okay out there in Kansas City. If on the provider side, if the state is directly enforcing the provider provisions of the NSA or doing so through a collaborative enforcement agreement with CMS, and we receive a consumer complaint, we will refer that consumer to the appropriate state entity and complaints intake location at the state level to file a complaint and seek relief. In those instances, states will lead enforcement efforts. And if a state has difficulty getting the provider or facility to take corrective actions, and that includes making restitution to consumers, they will refer that case back to CMS, and we will step in to enforce. We are aware that states often use a mix of different enforcement entities to enforce the provider provisions, with state entities like health departments, medical boards, attorney general's offices, and there's other models out there that we're seeing, and are leading and or partnering with the DOI on enforcement efforts in all of those different instances. We continue to reach out to states to ensure that our enforcement approaches are coordinated, reflect the most up-to-date state enforcement posture, and include communication with all applicable state entities. So a lot of this is, I mean, we've learned a lot in the last few years since the provisions took effect. These are different models, and so we are working at the CMS level to partner with states, and then to work with states to partner with all those specific entities within those states, based on what that model or that posture kind of looks like from an enforcement standpoint. Back to
Thank
Brian.
you. Thank you. Now, we only got about 3.5 minutes, so I want to dig deeper on just one thing before we go on. Is you talked about the cooperative enforcement agreements, and Jane talked about how to start out there with these letters, basically, between the federal and the state, who's going to enforce what. I just want to make sure everybody understands that can change over time.
Yeah.
So if your state is interested in revising that cooperative enforcement agreement, taking more or taking less, I know they don't like me to say that, but or you wanted to just improve in any way, you can go back to those agreements, back to those letters, and CMS is always interested in working with you. Something you said, Michelle, about the no wrong door. That's always kind of the tough part, since you have two laws really in a lot of states or several states going on. How do you make sure people have that no wrong door when they have a complaint that they're going to the right entity? Can you go a little more on that?
Yeah, I mean, I'm happy to. So our No Surprises desk has help desk agents, and we work with them to sort of train them on where, CMS has enforcement, where labor has enforcement, or where the state has enforcement. I think, as you mentioned, Brian, it is complicated. And so they do their best. They will refer a consumer to the state. But oftentimes I know we get, a consumer coming back saying, hey, we went to the state and they said it's not us, it's you guys, which is not great for the consumer. They get kind of bounced back and forth. But we do our best to kind of triage the complaints to the appropriate entity as best we can. And that no wrong door approach from the help desk really gives the complainant, whether it's a consumer or a provider, the information they need, the websites at the state level, the complaint phone number, et cetera, at the state level to follow up on that end as well.
State level, when you have state rules, you have also somebody to contact. It's kind of triages things, correct?
Right. So we're not going to ask a consumer to figure out whether their plan is fully insured or self-funded. And so when a complaint comes into us, or a self-funded health plan that's opted in, and if it's not, then we'll direct folks usually to DOL, because most often it's a private self-funded employer health plan that we're talking about.
Okay. And as far as education, how do consumers and providers know about all this? How do you do it at the state level?
So we've got a website that tries to help people understand that, but it's the same issue as with mental health parity. Don't ask a consumer to call you with a mental health parity problem. Consumers call with mental health or behavioral health access issues. And it's the same thing here. It's our job to figure out who's the right person to get them to, not for consumers to figure out what kind of health plan they're in.
At the federal level, your communication, how are you getting all this information out to the providers and the carriers and the consumers?
So we have several web resources that are available on the CMS site, and we can share all of that information, or at least the links as a follow-up here to the session. We're taking different approaches in doing outreach to issues and providers. I could speak to providers where, we have a targeted outreach plan, and we're kind of taking a look at all of the different complaints, consumer complaints that we've received, and sort of tying that to the specific disciplines where we're seeing trends to do some targeted outreach there. But also on the website, there are lots of provider-friendly presentations around meeting the provider requirements. and lots of how-to sort of guides that we're building.
Well,
I think on the issuer side, it's basically the same. Sorry, Brian.
We're out of time, but I think the bottom line, what we hope to get across is communicate. If you forget nothing or remember nothing else out of the session, they don't bite. So federal government is trying their best to protect the consumer and do what they can to help them, just as you are. So as you have these federal, state laws and coordination stuff going on, make sure you're communicating with people. Some of them are regional, some of them are nearby even sometimes. So make sure you're working with them, communicating with them, so everybody can help the consumer the best way possible. I want to thank all of our presenters, those here, those online. I don't know if Erica is still on the line, and Beth, but thank you all for your participation. Appreciate all your help, and we are done with this session. You guys have a good summit.